Let's call ready.
Yeah.
Okay. Fine. All right.
Yes, Mr. Pickford.
Our answers to the exam questions.
Could you just give me a moment to make a note?
Just make sure I've got them. I have. Yes, I have them.
Plant A, we say yes to paragraph 3 with 2 comments. One, this assumes that it is possible to split expenditure. And 2, this is a result produced by the legislation as it was crafted in 1994 and repeated in 2001, which asked whether you had expenditure on plant that was disallowed.
Applies to 1994
And as recast in 2001. The effect of list B wasn't that you were not plant, it was that the expenditure wasn't allowable. And that was baked into the legislation from 1994 onwards. And is reflected in the Upper Tribunal's paragraph 134.
Paragraph
134. And the law has changed in the Finance Act 2019, but it doesn't apply to this appeal. Just for your note, that's tab 6 in the authorities bundle. So as regards, that's always says plant A. Plant B, we say yes.
When you say assuming it is possible to split expenditure, I mean, how does it work if it's not possible to split expenditure?
Well, that depends, my lady, on the logically prior debate about entirety or piecemeal.
As I understood your submission, you were, in general terms, favouring what you described as the conventional view.
I am.
That once it was allowable plant, it was all or nothing for all expenditure on that particular piece of the piecemeal.
My lord, I am.
But your alternative position is that this is right if, in the alternative, you can split up parts of expenditure.
Exactly so.
Have I understood correctly?
You have.
So your primary position would be no to 3B, but your alternative position is yes to 3B if one can split up.
Correct.
Thank you.
So we, as regards plant B, paragraph 6, we say yes.
Oh, now I'm confused about what you say about plant A. Wait a minute. Right, so you say that conventional wisdom, which means that you can't split it, means that you stop at little a and you can't then go on to allow some expenditure.
Yes, that is correct, unless there is some part of list C you can point to, and this example assumes there isn't.
Seems there isn't.
Isn't.
So your primary case would be assuming that you can't split the expenditure and the peer is correctly treated as a plant, then it's excluded by item 5 of list B and it's not allowed.
Yes.
And it's not wholly within any item in list C.
It is not wholly within an item in list C. In a world where we are testing the expenditure on this item as defined.
But if you can split the expenditure, you agree you would allow the million.
Yes.
Yeah. Yes.
We say yes. Plant B, paragraph 6, we say yes. Paragraph 7 is from a learned friend. Plant C is not our case, I say, because we are structures. But with that caveat, we say yes to paragraph 12. We don't accept quite the way it's put in 12D, but that may not matter at this stage.
Yes.
As regards plant D, we say yes to paragraph 17. Unless I can help the court further, those are my submissions.
Thank you very much indeed. Yes, Mr. Brown.
My lords, my lady, would it be most convenient if I were to deal with the homework questions?
Whichever order you want to deal with it, Mr. Brown.
And it may be that what I have a reply about the interrelationship between 22.1a and 22.1b will to some extent explain the position I'm taking on the homework questions. On plant A, no, we respectfully disagree with the position which is attributed to us. And in HMRC's view, all expenditure on the provision of an asset, including excavation involved in its installation, is either allowable or is not allowable. So the expenditure on altering the land here is not allowable because it's on provision of an excluded asset, which is caught by 22.1a list B. also respectfully demur from the proposition that there is any installation in something like a pier within List B item 5, because it would be constructed or created in situ. That would obviously depend on examination of particular facts. On plant B, by similar reasoning, we respectfully disagree. There is no relevant works involving the alteration of land here. So all of the works qualify via List B item 7. Insofar as there are what you might loosely call groundworks, then they go along with...
You've got to answer the question on the basis of not arguing about what nature... What do you mean there's... No, you're saying that there can't be a plant B to which that applies.
Well, you have identified, my lady, a structure in use for telecoms purposes,
yes,
which falls within List B item 7C, is it? The whole of that structure therefore qualifies for allowances, and there is no disallowance caught by 22(1)B as works involving the alteration of land.
So you're agreeing with paragraph 6, is that right?
Yes. Sorry, I should have made that
No,
clear.
don't worry.
The groundworks are ancillary, a point which I've made in various contexts. So to provision. Let me be careful about how I phrase it. Provision of the structure includes the structure and the groundworks which go with it. So the groundworks are ancillary to the structure, and the provision includes the cost of all of them.
So it's almost the mirror image of plant A, really. It's the way you...
It's the same reasoning, yes. It all qualifies in plant B.
But that seems to me then a very different position from the position you took before either tribunal.
It's fair to say that, well, I intend it is fair to me to say, that the way in which my argument, as finally refined before the Upper Tribunal, wasn't fully reflected in the way in which the Upper Tribunal dealt with it. And certainly by the end of the appeal, the position I was advancing was that 22(1)B is addressing that category of alteration of land where the alteration is intended to produce land, which itself has the function of plant.
But is not a structure.
That is not a structure.
I'm trying to discern whether there's any difference between you
Right, I thought you were
on
bitterly
this,
opposed on
actually.
this.
22(1)B.
Well, there's not much difference between us. Where I do differ is where something is not, with the argument that something which survives disqualification in List B is therefore not disqualified by 22(1)B.
Well, but that was exactly the answer that you just gave. That if it's within item 7C of List B, it survives List B.
Yes.
Even though it's a structure.
Yes.
And I thought you then went on to say, well, because it survived list B, you then have to apply 22(1)B, and that was where you differed
No,
from what the Upper Tribunal had decided and what Mr. Peacock was arguing, right? But
where the structure involves, where provision of the structure involves as part of the activity of providing, and I call them groundworks, you know what I mean, that work will not be winnowed out from that expenditure and disqualified under 22(1)B.
why not?
Because the provision of the item includes the groundworks which go with providing it.
Because of section 22 something else.
Well, because that's what's meant by provision, and provision includes construction, and so you don't separate out the digging of the hole to put the item into. And were there any doubt about it?
But are there any of these assets currently in dispute that you say section 22(1)B is relevant?
Oh yes, the head race, the tail race, the drainage, the water.
But I think but they were held to be structured.
No, I'm going to address you on structure. The Upper Tribunal wrongly took the view that had been found. What the FTT said, and perhaps I'll just give you this sentence and then come back to it. What the FTT said was that it was common ground that if items were structures, then they were going to be saved by item 7 in list B.
Right, well, you'll come to that. Okay, so this all depends then. Because I think my lady would be right, wouldn't it? That we wouldn't get to 22(1)B on your submissions unless one or more of the things we're discussing here, parts we're discussing here, were not structures.
Yes.
Right. Well, that does clarify matters a great deal.
But we have made the point in writing, and I think I made it orally yesterday, that there is not a finding below.
No, well, you'll come
certainly
to
not
that. All right.
conceded below.
Yes.
That these items were structured.
No, all right. All right.
Right, but
Okay.
so you do accept that if something is a structure, you look at it, it's either in list B and excluded, or it's in list B and it's not excluded either because it's in list C or because it's in item 7A, B or C, and wherever you get to at that point, that is the end of it.
Yes.
You don't look at whether it involves the alteration of land.
You don't need then to start examining its foundations to see whether there was works involving alteration of land in its foundations. That's because, for the two reasons which I was at pains to make yesterday. One is that the groundworks are part of the provision, and in any event, list C item 22 would save the day. As a kind of avoidance.
Would save the day for the whole lot.
For the groundworks, if were that to be controversial.
Well, yes, I see. Anyway, if something is a structure, well, that's a slightly different point, isn't it? But if something, I understood you to be saying, if I can paraphrase it this way, but it may be wrongly, that if something is a structure, section 22(1)B does not apply to it. But I think you've added, well, that's either because it doesn't apply to it, or because item 22, whatever it is, this C disapplies it. But that's a slightly different point, I think, because that's that look at purpose,
yes,
installation.
The way in which your lordship phrased it wasn't quite how I wanted to be understood.
Oh, right.
Whether it was quite what I
I
said.
tried this out on you.
If something's a structure,
Yeah.
it may have with it groundworks which could be described as works involving the alteration of land. those works, the expenditure on providing those works, is part and parcel of the expenditure on providing the structure. So 22(1)(b) doesn't present a problem for the taxpayer.
Well, don't say it doesn't present a problem. That's too imprecise. Why does it not present a problem?
Because it doesn't apply.
Because it's a structure.
Because there is a structure.
Because there is a...
And the
plant is a
groundworks
structure.
associated with the structure, the cost of those groundworks goes with is part of the expenditure on that structure.
Right, so because the plant is a structure, and because constructing or acquiring the structure is part of provision of the structure...
No. Because the plant is a structure, that will include different elements. One is construction of the structure. The other is groundworks associated with the structure. There is no disallowance by 22(1)(b) because the groundworks associated with provision of the structure are to be treated as part of provision of the structure.
Why are they to be treated as part of it?
Because it's inappropriate to winnow them out. The structure is one thing, what is provided is one thing in its destination site.
This goes back to the entirety or piecemeal point, doesn't it? Yes.
But even if that position were not correct, list 22, if one were going down the piecemeal road, would still allow the groundworks element in addition to the base cost of providing the item itself.
Well, that I don't find that quite as easy because it's different language in item 22.
Well, different in the sense that it doesn't use the word works.
Well, it doesn't uses the word installation as well. So, I mean, I understand your argument to be that installation has a narrower meaning than that for which Mr. Peacock contends. Therefore, there may not be a... I'm not sure
Yes,
item... I don't think it's right to say that on your case, that item 22 will always provide the answer.
Perhaps my submission is best seen as predicated on the correctness of my position on only installing.
Well, I think we're better to focus on section 22 myself, rather than trying to factor in list C, which after all is intended to take things out of 22, yes, which would otherwise be in it. So I think it's legitimate to look at
I respectfully
22.
Agree with that.
And I mean, I think we've got your submission there. If something is a structure, it may have groundworks associated with it, but providing those works is part of the provision of the structure, and therefore section 21(1)(b) doesn't apply. 22(1)(b) yes, doesn't apply.
And that is regardless of whether it is taken out of the general rule by list B or whether it's not taken out of the general
Do you mean by list B or by list C?
By list B.
Item 7, I think it's the sort of,
well,
isn't it?
I'm sorry, my lady, it's my fault, but I didn't understand your question. I thought I'd got my position, and
I think
encouragement from...
My understanding is you're saying it's not a structure. That's pretty perfectly bluntly. If it's not a structure, 22(1)(b) doesn't apply. I mean, clearly, if it doesn't involve any works, it can't engage it. But you say if it's a structure.
It is a structure, not if it's not a structure.
No, if it is a structure. Well, sorry, if it is a structure, sorry, I got that wrong. If it is a structure, 22(1)(b) does not apply. That's right, is it? Yes.
So then there's nothing between the two of you, if that's right.
Because 22(1)B only applies to alterations of land that are not ancillary to provision of a structure.
Yes. I hope my answer to plant C is less controversial, and it is yes. We agree with the statement in relation to plant C under paragraph numbered 11. HMRC's view is that none of the expenditure could be described as installing because constructed on site, so not installed. Nothing is list C is applicable, and none of the £5 million is allowable. And plant D, this is the strong room in a bank. The prima facie disallowance is, we would seen as coming via section 21 and section 22 because it's a building.
Oh, right. All right, but if I'd chosen a different item in
Yes.
list C, which was more
Then,
directed at plant, if there are some.
Yes, so it would prima facie be excluded, but it's saved by list C item 12, which preserves plant treatment for strong rooms.
Right, and you don't have to go on to consider section 22(1)B.
Correct. Perhaps one should add that list C is in section 23. So the logically prior analysis would be to look, is it disqualified by section 21? Is it disqualified by 22(1)A? Is it disqualified by 22(1)B? And if you find a disqualification there, it's then, but only then, that you get into section 23 and see whether the day is saved by list C.
That's a logical way of doing it, although one might actually dash to the end and see if it's in list C and save yourself the bother. Yes. Mm.
Well, except that 23 has many more safe harbours, if that's not an unfortunate metaphor to use.
Safe harbours.
Safe harbours. In addition to list C, there's all those in section
Oh, well, I was thinking.
23(2). I mean,
Yes, there's other stuff there as well.
there's a lot of things there. But I'm assuming that someone has looked carefully through all those things and they're not applicable.
They're not in play in this case. So that, I hope, addresses Her Ladyship's worked examples. To a significant extent, I've now, in answer to questions from the court, explored what I was going to say as the first part of my reply on 22(1)A and B.
Yes.
But may I flesh it out just a little? I submit no magic in use of the word works, 21(B). In 22.1a, you have the disallowed item identified. So you look at the expense of providing it, and as we always have in mind, provision includes relevantly construction. So is it an aqueduct? The expense of providing, including constructing that aqueduct, is disqualified. That activity of provision will also, in ordinary parlance, involve carrying out of works. Under B, you don't have an identified asset to be disqualified. You don't know what it's going to be, as you, the draftsman, don't know what it's going to be. And as I think my learned friend pointed out earlier, you can't very comfortably, as a matter of language, say that you provide works. So use of works in 22.1b is a merely linguistic device, so as to identify what the disallowance is focused on. And I accept the way in which the FTT put it in a sentence, don't turn it up, it's paragraph 40 in the FTT decision in relation to 22.1b, that it's dealing with a situation where the alteration of the land is an objective in its own right.
An objective in its own right.
An objective in its own right, to produce land which functions as plant. Now, I've tried to think of some examples of land that functions as plant. There's a difficulty with doing so because Wimpey and Warland was decided in the Court of Appeal in 1989, and the classic judgment of Mr. Justice Hoffman in the High Court was a year or so earlier than that. And that case set out for us that core difference between premises, the place where you carry on your trade, and plant, the apparatus with which you carry it on. And the position was perhaps not quite as clear for Wimpey as it became afterwards. Again, neither Wimpey nor this following case, Scottish and Newcastle Breweries, is in the authorities, because we're not here arguing about the premises test. But there's a passage in the speech of Lord Lowry in House of Lords in Scottish and Newcastle. My learned friend referred to the case yesterday. It's the hotel. And there are various things. There are famously seagull sculptures, which are held to be part of the hotelier's plant because they add to atmosphere. But Lord Lowry makes the point in Scottish and Newcastle that premises are not plant, save in the rare case where the premises themselves function as plant. And if one's searching for an example of premises functioning as plant, you might look at the dry dock in Barclay Curl, as premises as anything could ever be, but held to have the function of a tool, like a huge vice for holding ships upright when the water was absent. And Lord Justice Fox in Wimpey cites that passage and adopts it as his own. Premises are not plant, save in the rare case where premises function as plant. Now, in order to assist the court, I've tried to think of examples which might be disqualified by 22.1b, which aren't structures. I was rather taken with my learned friend's example yesterday of the earth bank at the shooting range, which functions as a backstop.
Yeah.
But even that example, clever though it is really quite vulnerable to the proposition that this is part of the premises. You're conducting your shooting range trade at the shooting range, which is configured suitably for a shooting range. But it's a good example if one parks the premises test and is looking for what might be disallowed by section 22(1)(b). Another example which occurred to me yesterday and then was previewed by Lady Justice Rose today is a cycle track, as I saw it, a BMX cycle track, which will consist simply of earth banks and hollows and runways, may well be constructed with a bulldozer with absolutely no further input of concrete or steel structures or anything else. That would be an alteration of land. It would certainly be disqualified by section 22(1)(b). And depending on in which order one addressed the question, it would fail the common law plant test anyway, because it's premises. But after 1989, when Wimpy and Warland met the Court of Appeal, this area of the law was constantly enlivened by cases in which people tried to establish that what you would, in a very loose sense, call premises, places, nonetheless functioned as plant. I think I mentioned yesterday car parks. There was a lot of litigation about supermarket car parks, the core contention being that the supermarket sold groceries with the car park rather than at the car park. That issue was taken away, though without retrospective effect, by the 1994 legislation, which expressly excluded car parks, hard standings and the like from allowance. So, in fact, most, if not all, of that litigation ended in the Wimpy and Warland answer that, well, of course, the car park is a place, it's not, doesn't have that character of equipment or apparatus. But the 1994 legislation would have dealt with the point without further investigation. So 22(1)(b), my submission, is aimed at producing that land, forgive me, aimed at disqualifying land which is configured so as to function as plant. And as I've already explored in dealing with the worked examples, it's not aimed at groundworks which are ancillary to the structures.
So in case anyone should think of some plant which is a configuration of land functioning as plant and does not involve a structure but also is not taken out by being premises, there's 22(1)(b) to hit it on the head in any event.
Just so, yes. I was trying to think of centre parks type leisure facilities which might have rides and...
Well, my lady's example, again, I mean, subject to the premises point.
Yeah, yes,
that's
that
probably
very
as
much
good as
so.
you get, isn't it?
Another example, which I mentioned, as I see it in my notes, is a grassland racehorse gallops. So the, in Berkeley Curl, Lord Reed says land in its natural state is not plant, even though its quality has been improved by cultivation and so on.
Yes.
A trade of horse racing, again subject to the premises point, may...
Right, okay.
It's another example, although the cycle track is perhaps
Yes, maybe.
enough examples for now.
Actually, you put a gallop on a flat bit of land, don't you? And then mow it to the length you want. Yeah, well, perhaps we shouldn't go there.
Don't go there.
We
I've done
won't
two
go there,
cases
don't
about
worry.
racehorse gallops, not involving natural land.
No, no.
Um,
Croquet lawns. Right, okay. Right, so that's really, is it on 22.1b?
yes, and item 22, that's to say list C, item 22.
You want to go straight to that now, do you? Coming back to tunnels and things? Or?
I've made my submissions on tunnels and aqueducts.
Okay.
My learned friend has said,
Fine,
well, he
that's-
doesn't agree with it
no.
and prefers
Yeah,
his approach.
that's fine. That's fine.
Unless the
So,
court
no. Sorry, I was just.
proposing.
That's fine. No.
So list C, item 22, makes clear, and I'll just say this and then move on, that excavation works for installation of an item are not disallowed because they involve land. You test the proposition by forgetting about the concept of plant and of premises. And remember that list C, item 22, also applies to machinery. One example which my team we constantly discuss is something like a car park ticket barrier, which is undoubtedly machinery.
Yes.
And maybe manufactured elsewhere, brought on a lorry, and it needs to be installed.
Yes.
And land has to be altered for that. So a hole has to be dug, a concrete base poured, and then the item is bolted to it.
Yes.
That alteration of land is for the purpose only of installing machinery, and is foursquare within item 22 of list C.
Right, so even though the car park comes out under list B, item 2.
Yes. The car park as a piece of land is not plant.
Right.
It's premises and it doesn't function as plant, but anyway, it's taken out by list B.
Yes.
But a car park will often have items which are plant or machinery or both, and a rising and falling ticket barrier is a good example of that. There will be other examples which could readily come to mind.
Yes. Right. Right. Thank you.
Now, I wanted to make the point about structures
Ah, yes.
and how there is no finding against us that these items are structures. And we've made this point in writing. May I draw attention to it? It's in our supplementary skeleton argument, which is at the core bundle, page 43. My paragraph 125. I refer there to the FTT's decision at paragraph 43. Please bear with me while I find it. high point is at paragraph 43, which is in core bundle page 151. And as we observe in writing, the parties were agreed that any relevant structures would be saved by list B item 7A. It is not, falls short of a finding that any of these assets were structures. And it's significant to take my favourite asset, the head race, because it's a void. Essentially, it is a void. After the collapse and the need for construction of the dogleg detour, there was further strengthening added to the head race, certainly in parts, because there was a fault in the rock. It's all set out in the Octave litigation. But it's never been suggested, and I don't understand it to be suggested now, that addition of some ancillary shotcrete or rock bolts or reinforcement to the bare head race turns what was not a structure into a structure. And there's no finding that it did. Of course, the FTT in relation to the head race held that it was or resulted from works involving the alteration of land. Didn't give us the allowance, didn't disqualify.
Am I right in thinking that you define a structure? I'm not sure quite where we get a definition from, but I've understood from your submissions that in a definition of a structure, apart from it having to be a fixture, is, you say, something other than that which comes within 22(1)(b). So it's something which is not land which is configured so as to function as plant.
Well, that is...
Is that your definition?
Adopt that as a definition. I accept the proposition that land of the nature what you've described will not be a structure.
But what?
That will not provide a definition of what a structure is. We have it, to the extent it could be graced with the term definition, we have a definition in section 22(3) that structure means a fixed structure of any kind other than a building.
But you could obviously have quite a lot of plant and machinery which wasn't a structure.
Yes.
For example, an old master painting.
So what is it that, why is it that you, which of the items that we've been discussing do you say are not structures?
The head race, the tail race, the dewatering tunnel, the ancillary tunnel, I've forgotten what its name is.
Well, before we get into the detail of this anymore, are you coming to paragraph 145 of the Upper Tribunal's decision? That's the question I have of Mr. Peacock, if you're rising.
With trepidation, but my learned friend is pursuing a point for which he has no permission to appeal.
Well, let's take it in stages. Can we start with paragraph 145 of the Upper Tribunal? Mr. Brennan.
Yes, Madam. Sorry, I thought Madam Friend had more to say.
Because Mr. Peacock drew our attention to this, and it contains an express finding, as I read it, an express finding by the Upper Tribunal that all the items in dispute are structures. That's the sort of first point.
Your Lordship, bear with me. I'm sorry, would you give me the page?
Yes, it's page 117 in the core bundle.
Yes, well, there are two problems with the approach there. One.
Well, sorry, can I just be clear? They do say, don't they? They're making a finding of fact that all the items in issue are
Yes, they do
structures.
say that.
They do say that. Now,
But they have
before-
not done so.
Sorry, go on.
They have not done so, having identified an error of law in the first-tier tribunal.
Well, but I mean, then that leads to the second question, which I suspect is what Mr. Peacock was rising to say. Where do we find this in your grounds of appeal, and where do we see that you have permission to raise this before us?
Well, you don't find it in my grounds of appeal. I just need it.
Well, I think you do, because they've made a
because-
finding of fact. Now, if you're going to
because
say, so I mean, this is all. I'm not sure how much of this you opened on anyway, but what's the basis of your challenge to the finding of fact that they had no jurisdiction to make it, or no Edwards and Bairstow, is it? Or
Well, they needed to say Edwards and Bairstow on the part of.
well, but have you now challenged? I mean, but you have to challenge their finding of fact on the basis that it wasn't open to them.
I think I have to accept what your lordship says about that. I don't have a ground of appeal
So you don't have permission to raise.
expressly challenging the structure's point. Of course, that doesn't lose me the day because it's only relevant to the extent that the structures can be shoehorned into item 7 of list B, and then mutual exclusivity.
But even without,
Absolutely. Sorry. I mean, I think what it does mean is that section, just to be clear about this, section 22(1)(b is not relevant for our resolution. There's no issue arising for our determination on section 22(1)(b, given the Upper Tribunal's finding that all the items in issue, all the assets in dispute, they put it, were structures.
I'm being summoned.
Yes, do. Apparently
I've been sent a message which
Yes.
I haven't yet read.
Oh, right, okay. True. Yeah.
Yes, the point has been made, and I should have been quicker to answer your lordship with it.
Yes.
I respectfully disagree with your lordship's point
Right.
that 22(1)(b) is not relevant for the court's consideration because this goes to mutual exclusivity. Suppose.
Well, look, can we just take things one at a time, please? Sorry, I'm getting confused. Just so I'm absolutely clear about this, we should proceed, is this right? We should proceed on the basis that all the assets in dispute, as the Upper Tribunal called them, have been found, as a matter of fact, to be structures.
May I just confirm
Yes.
that, because I don't want to give the point away.
No. That's
There's
right.
nothing between.
We all get on to tunnels. That's right. Yes.
Yes. My Lord, I don't feel in a position to concede what your Lordship has put to me, but I have to confess to my difficulty with it, that I accept we do not have a ground of appeal, still less permission to advance it on that finding of fact which your Lordship has just put to me in paragraph 145.
All right. Thank you very much.
I think I'm going to have to proceed on the basis that your Lordship will proceed on the basis of this structure.
They're all structures.
No.
But then, yes, what follows from that?
What follows from that is that there is nonetheless, in relation, say, to the headrace, alteration of land, works involving alteration of land, and I have a finding of fact to that effect of the FTT, even if there is a structure, that works, those works involving alteration of land are designed to configure the land so that it functions as plant, and it's therefore disqualified by 22(1)(b).
Even though it's a structure.
Yes, so if it's a structure, it can be saved from by List B, item 7A, from disqualification
Correct. Yes.
by item 7. If it's an aqueduct, it's disqualified by earlier.
Yeah, no, I understand that. But
If it's a structure, all that tells you is that it is not disqualified by List B, item 7.
Well, but it has. No, that's not the result of it being a structure. That's the result of it being an industrial building.
Yes, but it's got.
That's not a structure. I mean, all the things in List B are structures.
yes.
Item 7.
Structures or other assets.
Or other assets.
No, but in order to come within item 7, it has to be a structure.
It has to be a structure,
Yes.
and it has to be a structure that's not within the other item.
Yes.
Right?
And
So you are still saying that even if it's a structure, if it's a structure that is not excluded by List B because it falls within item 7, A, B or C, you then do have to go on to consider whether it or some of it is a work involving the alteration of land. So then we're back to where we all thought we were.
we're back there because in this specific, in relation to this specific asset, the works involving the alteration of land produce the configuration of land which functions as plant. And that's why mutual exclusivity, as the Upper Tribunal characterised it, is incorrect. Because what they said was that if something is saved from disqualification under List B because it fell within item 7 and qualified for industrial buildings allowances, you didn't even need to look at 22(1)(b. But my submission is that you do need to look at 22(1)(b, and in relation to the headrace, which is where we're currently.
So then the savings in 7A, B and C of List B operate in a different way from the savings in List C, because I think you accept that if something doesn't fall within List B because it's in List C, that is the end of it, and you don't then go on to consider whether it's within section 22(1)(b.
That's correct, because List C is a general saving function which applies to section 21 buildings, 22(1)(a, List B, and 22(1)(b, works involving the alteration of land. So List C is a general get-out. So if the asset is within any limb of section 21 or section 22, List C will save it if it falls within.
So if it is only saved because it is in item 7, A, C, then you do have to consider whether it's also within section 22B, 22(1)B. And then you presumably have to go back and look at whether it's saved by anything in this C.
In this C, yes.
So, because, I mean, I think when we come back to the submission you made in opening, that 22(1)B, I jotted this down, is land that has been altered so as to function as plant.
Yes.
So the BMX track is,
Yes.
is an example of that.
Yes.
But could you really say that a BMX track is a structure?
I'm not trying to say that.
No. What you're saying is a BMX track is not the only kind of thing that falls within 22(1)B. Also within 22(1)B are structures which happen not to fall within 22(1)A because they fall within item 7A, B or C.
And that element of mutual exclusivity, or as I would have it, lack of mutual exclusivity, kicks in where you have the alteration of the configuration of land so as to function as plant.
But if 22(1)B can include a structure, how do you apply 22(2) to it?
I'm not aware that I said that 22(1)B can include a structure.
Oh,
But
yes,
the head race has been found to be a structure.
I'm sorry, I misunderstood your ladyship's question. I'm sorry, I was concentrating on the works.
Yes, all right.
The head race
Yes.
had produced a structure, as I'm stuck with that finding of fact. But the head race results from works involving the alteration of land. And as I certainly said in opening, probably more than once, those are two disqualification bars. So the mere fact that you survive disqualification by 22(1)A and list B does not mean that you survive disqualification by 22(1)B. That's not because 22(1)B produces a structure. What has happened is that it has been produced by works involving the alteration of land.
Well, what you say being produced, I mean, it's the alteration of land which actually creates the plant. That's the point, isn't it? That was back to your definition. It's land that's being altered or has been altered so as to function as plant. It's the land that functions as plant, not something that's been built on it or in it or under it. Not a sort of, it's the land itself, the BMX track.
And you do have what I seem to remember.
That could be, you say it may be defined, or found, sorry, not defined, found to be a structure, but it's still land that's been altered so as to function as plant, and is therefore B.
Yes.
So my question then was, how do you apply section 22(2) to that?
Well, 22(2) is telling you what is meant by provision of a structure or other asset.
So that can take all the sort of ancillary groundwork, as you called it, out of 22(1)A, but when you recast that plant as being in 22(1)B, 22(2) provides no assistance to the taxpayer.
Exactly. You've got to ask, for the purposes of identifying what is disqualified by, what expenditure is disqualified by B, you ask what expenditure was incurred on altering the land, and it is that expenditure which is disqualified. And you don't need to ask what is included in the expenditure on provision of a structure, which is the question to which section 22.2 is addressed.
And how then does that fit with section 22.3b, which says that land for these purposes does not include structures?
Because the one started off with virgin land, there was no alteration of a structure. And still dealing with the head race, an aperture was bored into the land. So the works which were carried out so as to be caught by 22.1b were still works involving the alteration of land. They didn't involve the alteration of structures, still less buildings.
Yes, but your definition of what 22.1b is aimed at, the outcome, is that it's aimed at land which is configured so as to function as plant.
Yes.
Well, then you're looking at it in its final position as configured, the outcome.
Yes.
If it's a structure, it can't be land within the meaning of the section.
But what's disallowed is expenditure on the provision of works involving the alteration of land. And the land which is there altered is the original rock through which the tunnel boring machine drilled.
So I think you're not using works as a noun. You're using works as if you're reading 22.1b as if it meant any alteration of, or any work done to alter land or something like that.
Well, I know I've said so often, but I keep coming back to your definition because we can anchor it to that. What B is aimed at is land that is altered so as to function as plant. It's not the alteration of the land is not ancillary to anything. It is actually, it's the alteration which produces the plant.
Yes.
And the BMX track is always the one, I think, to keep in one's mind. So it's not sort of cutting up the provision into different constituents, as I understand your submission. It is that the provision is the alteration of the land. That is what provides the plant. Am I right in that? Because if I'm wrong, then I'm really at sea.
What one has to concentrate on is what expenditure has there been on works involving the alteration of
I understand that, but...
it is that which is disallowed.
Exactly.
That is what the taxpayer is claiming.
Well, but that's in the case of the head race, you say. Because you say that is just... Because the head race, you say, is itself simply the product of the alteration of the land. I think that's what you're saying. So we're not looking at cases where the plant is a piece of equipment which is housed, having carried out works to the land or anything like that. We're looking at just in a sense reconfigured land.
Yes.
Right. And that can be a structure and has been found to be a structure, but that doesn't prevent it within little b, 22.1b.
It doesn't prevent the expenditure on having been on works.
No, but the end product can be a structure, even though it's just reconfigured land, you say can be a structure.
Well, as I'm...
Because if it can't, then you can't be within B. Do you see what I mean? Because these have been found to be structures.
Yes, on that basis, yes, but the reconfigured land here falls, as you know, I contend, within B.
No, we're trying to explore
Yes.
quite why you say that. Yes, I see.
And you do say, I think, that 1b means any work involving the alteration of land, i.e. the activity, rather than any works, in the sense Mr. Peacock gives, meaning the product of the outcome of the activity.
I accept it. It's capable of two readings because, but if Mr. Peacock's noun is correct, it really works involving altered land because he's looking at the consequent, as it were, earthworks rather than the activity of altering it. But
Yes. I'm not sure, as I said, I'm still not sure there's any difference between you as to what 22.1 encompasses.
Well, I think that the difference is what is the effect of the two provisions in relation to a structure which falls within item 7A, B or C. Mr. Peacock says, and the FDT and the Upper Tribunal agreed, that if it's a structure and then it's covered by list B, or else it's not covered by list B and it's disallowed or allowed on that basis, and that any works involving the alteration of land is looking at something other than structures. Whereas what you say is, if it's a structure that's not excluded by list B because it falls within item 7, A, B or C, then you do go on to say, well, albeit it's a structure, is it also an alteration of land arrived at by works involving the alteration of land? And if it is, if you could also describe it in that way, then it's excluded by 22.1b, unless you can then bring it within C.
yes, and that notwithstanding that, as the Legislature said, that it has made its way through list B.
And you say that, well, it's almost impossible to think of something which is installed in the meaning that you give to that word, if it is an alteration of land functioning as plant, because I suppose you could bring a whole lot of heap of earth and pour it onto the ground. I don't know.
Well, it's got to be the plant or machinery that's installed. So
Yes,
that's
exactly. No,
difficulty.
that's so, because it's very well. One can't really think of an alteration of land which is installed in that narrow sense.
Not in that sense. Of course, it would be. It would work on Mr. Peacock's construction of the word installed. Well, I think we think that we have your submission, Mr. Brennan. Just to be clear about this, Lady Justice Rose put a proposition to you as to as she understood your submission on this to be, and you did agree with it. And it struck me at the time as she was putting it to you that it did seem to me very, very neatly to encapsulate what your submission is on this.
Is your Lordship referring to the exchange moments ago?
Yes, well, yes. Lady Justice Rose sort of put out, as it were, she tried to verbal you, as it were, but she put out the submission, and you did agree with it.
I think I did.
And but I don't know if yes. Are you you're content?
I'm content that I've made my points to
Yes.
the court. Yes.
Very well.
The court has my points, I think, on installation and on pipelines.
Yes.
On the procedural point, the point which I think I've made in writing, but I want to stress, is that a respondent in the Upper Tribunal has the opportunity to put in a respondent's answer and to identify, this is Rule 24.3, don't turn it up,
Yes.
points on which he was unsuccessful below, but on which he wants to rely before the Upper Tribunal. And my learned friend did that on other aspects, and there is no possible objection to it. But in my submission, the critical point of construction that comes out of that rule is that where it refers to the grounds on which the respondent relies, it is referring to his reliance in his character as a respondent to the other side's appeal. So he sets out the grounds on which he relies in the appeal, but it isn't his appeal because he's responding. And if he wants to be an appellant, then he needs to get before the Upper Tribunal in the character of appellant rather than respondent.
Yes.
So the question for the Upper Tribunal was whether what the learned friend was doing was appealing when he wanted the decision below varied in his favour in relation to that particular asset. That, I submit, clearly connotes an appeal, and the tribunal lacked jurisdiction to entertain it because of Section 11 of the 2007 Act. And finally, my learned friend said, I think perhaps with some encouragement from the court, well, it can be dealt with as a matter of case management, to which the answer is, oh no, it can't, because if he has got a right to run the point without any leave, permission, it is not an appropriate exercise of the tribunal's case management powers to say that he can't, because there's no other abusive behaviour which might entitle the tribunal to strike him out. So it would simply be palm tree justice if the tribunal looked at his point, looked at how much it would or wouldn't consume of the tribunal's resources in order to determine it, and made a decision as to whether he was going to be allowed to run it.
Well, I suppose the only point might be this, mightn't it, that the tribunal, either of its own motion, I'm envisaging this before the hearing, or maybe prompted by the other side, would say to the respondent, this point you want to raise has no real prospect of success. And unless you can persuade me it has a real prospect of success, then we're going to dismiss it now. I mean, that would be a proper exercise of case.
That would be a proper exercise of case management powers,
Yes.
but it wouldn't engage with the fact that they don't have jurisdiction to consider it.
No, I thought you
because
meant...
of the lack of permission.
No, I understand that. I thought you were meeting another point. If you don't need permission, don't worry because it's dealt with by case management powers.
It may be I misunderstood my learned friend's point, but I didn't understand him to be saying that the tribunal can strike it out if it's hopeless or whatever, because that is clearly something which is a matter of case management, a modern...
No, I understood him to be saying, well, you needn't worry that permission isn't required because the tribunal has adequate case management powers to get rid at an early stage of a point that has no real prospect of success.
But suppose it's got some prospect, but not very much.
Well, then you would normally get permission to appeal.
Well, you might do. But
well, I mean, that's the thing. Either you do or don't have.
I'm coming back round the house.
I mean, I'm assuming it's real. I'm actually not. I mean, is real prospect of success the relevant test for the tribunal? I don't know.
I thought your concern was that you start an appeal, you decide, well, I'm only going to appeal a little bit, because I don't want it to go on for ages and cost a huge amount of money. But this point is very important for us for lots of other reasons. Then you say there's no mechanism by which anybody can limit the opening up of the proceedings to encompass everything that was decided. Well, that in a way is a hazard of appealing in the courts as well as in the tribunal, because I'm not sure that either in a case management situation or in a belated application for permission to appeal from a respondent, it would be legitimate to refuse permission on the basis of, well, that opens up a whole lot of other issues that have not been raised on the appeal. That's not a reason for disallowing permission.
If there's an arguable point of law, then clearly the tribunal will, subject to considerations of time and prejudice and so on, grant permission to argue it. The problem, though, is my learned friend's rather more emphatic case that it's open house. Once the Secretary of State or one other of the regular litigants before the statutory tribunals wants to argue a point, perhaps of general importance, you can be faced with an appeal on all of the merits, dressed up as a point of law, because of course Edwards and Bairstow is a point of law, with no permission at all, in circumstances where, had that point been raised in a conventional application for permission before the first tier tribunal, it would have been filleted out, or the tribunal...
When you say filleted out,
let me
what do you mean?
Say what I meant by that.
Yes.
The first instance tribunal,
Yeah.
which has, promptly after it has delivered its decision,
Yeah.
an application for permission to appeal on, let us say, a dozen grounds,
Yes.
yes, some of which are really irrationality, is in a position to say, you know, I'm going to refuse you permission on grounds 1 to 11, and I was the tribunal who decided the point, so I've got some recollection of it and what my thinking was and so on.
Yes.
But you can have permission on 12.
Yes.
On my learned friend's approach, that important filter, which is there for the other side and for the time and resources of the courts and tribunals,
Yes.
is simply thrown away. The first tier tribunal is never asked.
I see.
And
Because
it comes before the upper tribunal,
I see.
which is thrown back only on case management.
where I see, because you have to ask the first tier tribunal. Well, unlike in ordinary court proceedings, where you can just ask the Court of Appeal, you have to ask the first tier tribunal.
And must be a reason for that.
Oh, maybe I'm wrong about that, but I thought actually, certainly it used to be the rules, that you didn't actually have to ask the first instance judge. But anyway, you say that's an important point. It is that the normally it's the tribunal, the judge who actually heard the case, who will decide initially whether to give permission. On the other hand, the upper the upper tribunal may be faced with a renewed application.
Yes, but if it is faced with such an application, it will be faced with it armed with the first tier judge's views about the merits, so that whether there are a dozen points, you can look at it and say, well, I can see now why Tribunal Judge Smith refused permission on grounds 1 to 11.
Tell me, it is I just couldn't see it, but the test for giving permission to appeal, is that stated in the rules?
I don't think it is. Mr. Ripley seems to know better than either of us, but...
Ms. Ripley.
And so it's not stated in the rules anywhere, but the test that's applied normally is just, is it arguable?
Is it arguable? Is there a arguable with a straight face?
Yes.
Yes. All right. I mean, that is probably a real prospect of success, actually, isn't it? Yes. All right, thank you very much. All right, well, thank you, yes. I mean, I think this is a little bit, because this isn't actually at the core of it. This was actually Mr. Peacock raising this for saying, well, look, don't worry too much, because even if we don't need permission, the tribunal has case management.
Yes, my core submission is it's starkly there in the rules.
I follow.
The tribunal can't just give itself jurisdiction. Unless I can assist the court, those are my submissions.
There was just one point that Mr. Peacock made a couple of times about what is a finding of fact as regards the application of the definition to the assets. Now, I can see that the question of what the word tunnel means or aqueduct means in this B is a question of law. What actually the plant is comprising in terms of, is it bored through the rock, has it got concrete sprayed on it, has it got steel mesh? That's all a question of fact, and we obviously can't go behind that. But Mr. Peacock was also saying that the question of whether, given how we construe the word aqueduct, and given what this actually is, this thing, is it an aqueduct? He says that that's a finding of fact, which the Upper Tribunal cannot go behind. And he cited several times a case, name escapes me at the moment. Now, is that accepted by the revenue?
Once the correct legal parameters of, say, aqueduct are defined, identified, I accept it is a question of fact whether a given asset falls within them. So, try to simplify it. Suppose the only things that you needed in order to have an aqueduct were a channel of some description for the transport of water downhill under gravity, and there was nothing else involved. That would be the legal elements of aqueduct, and whether this particular item is or isn't within those parameters would be a question of fact. That's why I referred to Clark and Perks, which was that case about what constitutes a ship, and the Court of Appeal held that the final question was in effect exclusively within the jurisdiction of the first tier decision making. And the underpinning law on that was its decision isn't in the House of Lords and Cousins and Bruce's about what is or isn't disorderly behaviour, where somebody ran onto the centre court at Wimbledon, and that's a jury question.
Yes.
As Cousins and Bruce decided. Ms. Nathan draws my attention to the paragraphs in the Upper Tribunal where this is discussed. She points me to paragraphs 53, 54 and 89. That's references for the courts.
Thank you very much. Mr. Brennan, thank you very much indeed.
Thank you very much.
Mr. Peacock, you rose during Mr. Brennan's submissions, but I mean, in the light of the course of the submissions after that, was there anything you wanted to say? Not by way of rebuttal, but just was there a point where
nothing at all?
No. All right. Thank you.
Save this, that your lordship asked about a transcript.
Yeah.
Yes.
And we will endeavour to procure one. We
Yes.
understand that it's either necessary or helpful if the court
Yes.
gives us an order.
Well, and if you need, I will direct that.
Well,
If you need it in writing, I
We
can
have a
sign.
form here which we can either hand up or email.
Why don't you hand it up now, if that's all right, and I'll sign it.
And this is in an agreed form.
Right. I think, thank you for mentioning it, because I think we do feel it would be extremely helpful. So I'm very grateful.
I understand it will speed the process if
Yes,
the
certainly.
service knows that you really do want one.
The date today is the
9th?
9th. Thank you very much. Thank you. Very well. We'll reserve our judgments, which will be dealt with in the usual way. You're all very familiar with what that involves, so I won't recite it now. Thank you both. Thank you all very much for your submission.